Well, I'm from Somalia. I was born in a small town in the northeastern part of Somalia, but I grew up later in Mogadishu. I went to school in Mogadishu and I studied at the University of Mogadishu. I came to law by accident because I wanted to study medicine, but there was no faculty of medicine in Mogadishu. There was a faculty of law. So I just joined the faculty of law. I said I might as well study law. And then, of course, as I was finishing my legal studies, I wanted to choose an area in which I should specialize. And when I was studying law, Somalia was involved in territorial conflicts with Ethiopia and Kenya. And I was a little bit interested in how those kind of conflicts should be settled peacefully. And I decided to write my thesis on that, but on the role of the Organization of African Unity on the peaceful settlement of disputes in Africa. And that is how I got into international law. And then I decided to specialize in that area of international law. And luckily for me, I was asked to become a lecturer at the Somali National University. You know, a matter also of circumstances and luck, I should say, because the Somali government was trying to replace the Italian lecturers in various faculties of the university in Mogadishu. So I was the first Somali lecturer in international law at the Somali National University. And I had to learn on the job. At the same time, I had to act as a legal advisor to the Ministry of Foreign Affairs because the Ministry of Foreign Affairs did not yet have a proper legal department. So I found myself teaching and traveling all over the world because whenever there was a major conference in which negotiations involved in international law, the ministry would ask me to accompany a delegation. Sometimes in a, with a few hours notice, you have to go to the airport. The president's delegation or the foreign minister's delegation is going to that country and they require your legal advice. And so it was really a profession that was in high demand at the time in the country. And I decided to embark on that profession at the right time in Somalia. And then when I left the country, I did my PhD in Geneva, and I joined the United Nations, and I just became a professional legal advisor to international organizations, moving from one organization to the other and advising them on intergovernmental issues. And of course, when you have been dealing with international law at the national level and advising the government on international issues. And afterwards, when you have been advising international organizations on intergovernmental issues and trying to help the organization to deal with the relations between states with respect to the mandate of that organization, you are all the time dealing with dispute settlement. You are all the time dealing with the development and interpretation of international law. You are all the time dealing with the prevention of conflict among states. You are trying to promote better relations between states. And therefore, my vocation became peaceful settlement of disputes, better relations between the states, the promotion of peace and justice among states. And that is what international law led me into. And I decided at a certain point, because, and this thirdly, of course, I could say, that it came also by chance because I was working in UNESCO. I was the legal advisor of UNESCO, and there was a case that was brought to the International Court of Justice by Djibouti, the government of Djibouti, against France. And the government of Djibouti was looking for an African judge who could be appointed by the government, since they did not have a judge on the bench. And a judge ad hoc can be appointed by a government which is involved in a dispute if it does not have its own national on the bench. And so the government of Djibouti asked me if I could accept to become the judge ad hoc of Djibouti in that case. And I accepted. And then I thought maybe I could become a regular judge of the International Court of Justice. I decided to run for the election to the International Court of Justice, and I was elected. And here I am. Now, about the court. As you know, it is a court which actually deals with disputes between states. You have talked a lot about accessibility to the court. Well, the court has a long history. It is not the first court which deals with the settlement of disputes between states. It has a predecessor, which was called the Permanent Court of International Justice. And its predecessor was a court which was extremely careful about the representatives of states and about the states that appeared before it. Why? Because 100 years ago, 150 years ago, international law was not what it is today, number one. Number two, states did not accept to submit themselves to a judicial mechanism for the settlement of their disputes. You are perhaps used, and we are all used, including myself, to a world in which governments appear before courts and subject themselves to a determination of the law and to a decision by 15 or 20 judges. This has not always been the case. 100 years ago, when the major powers of the world met here for the Hague conferences, and the last one was 1907, the only type of dispute settlement institution, apart from, of course, negotiation, mediation, and conciliation, which they could accept was arbitration. They were not yet ready to accept a judicial settlement of disputes. And so there is always some sort of a reluctance on the part of states to submit themselves to an independent judiciary which would decide on the outcome of their disputes and which would decide how their disputes should be settled. So it should not be surprising for you if the accessibility to the court up to now has been a limited accessibility. Because even the institution of intervention, which is an institution that is recognized in the statute of the court, the Permanent Court of Justice, of the Permanent Court of International Justice, and even the International Court of Justice itself, felt for a while that if they brought third states and they allowed third states to come into a case between two states, actually governments may decide not to come before the court anymore because there are these third parties that are allowed by the court just to intervene in their bilateral dispute and to express their views on their bilateral dispute. And so the court avoided for a very, very long time the authorization of third states to intervene in a bilateral dispute between states. And because of the tradition established by the Permanent Court of International Justice, even the International Court of Justice itself paid a lot of respect and treated with a lot of caution the states and the representatives of states that appeared before it. So it is the issue of sovereignty of states which actually led to mainly to the reluctance to submit one's disputes to the International Court of Justice. But we know that the concept of sovereignty has evolved. It's no longer the concept of sovereignty of the 19th century. There is a new concept and a softer type of sovereignty that is applied and used by states in their international relations today. So this has allowed not only the existence of the International Court of Justice, which of course is the principal judicial organ of the United Nations, was the first international court at the international level, but the creation of other courts, of specialized courts at the international level, courts at the regional level on human rights. In the African continent alone, there are 6 regional courts now which deal with regional, sub-regional economic integration issues.